A very good morning to all of you. Under the Pan-India program done by the Ministry of Justice and executed by the CEERA for the National Law School of India, a series of lectures are being promoted. And today I am going to speak on the concept of legal aid and its implementation in India. Now, when we speak about the concept of legal education in this country, we have to think about our constitution. The Constitution of India has provided various rights to the people of this country, whether they are in majority or whether they are minority, are entitled to have certain basic rights. And in order to realize the very objectives of these rights, the Constitution of India has provided Part 4 of the Constitution. Under Part 4, which is called as the Directive Principles of State Policy, a series of objectives are being enunciated. And these objectives are enunciated for the simple reason that the country should become an egalitarian society. The principles of equality should be enforced everywhere. Now, in spite of all these things, as the great Martin Luther King has pointed out, what we call as an object which is called as injustice, which is anywhere, is a threat to justice everywhere. So in order to get rid of injustice, a series of measures were taken by the government of India. Now, one such measure happened to be what we call as the Legal Services Act, which was enacted by the government of India in the year 1987. The Constitution came into force, but then the 14th Law Commission of India, which was enacted, which submitted its report to the government of India in 1958, pointed out legal services should be provided. Legal services are to be provided, especially to the poorest, to the poor of the people of this country. They cannot have access to justice. Basically, they are illiterate, they are ignorant. In situations of this kind, naturally, it should be done. But then it did not realize until what we call as the amendment, which was adopted in the year 1976, which is called the 42nd Amendment of the Constitution of India. The 42nd Amendment of the Constitution of India naturally provided an article which is called as 39A. For the first time, 39A went to the extent of providing legal aid and legal assistance to everyone who is interested in obtaining it. Now, there are plenty of people who may not have an access to justice, and those people were taken into consideration. The people who come in the rich category or in the middle class, they don't need anybody. But there are certain people who are not in a position to go before the court of law and to fight a case and fight the redressal mechanism to get justice. In situations of this kind, the constitution makers of the parliament thought of these people, and in order to provide a remedy to them, introduced the 42nd Amendment Act. Now, thereafterwards, as early as 1972, a committee which was appointed by the Supreme Court of India for the implementation of this was headed by Justice Krishna Iyer and Justice Bhagavati. And they have formulated a series of rules for this purpose. And the contribution of these two great men were immense. However, in situations of this kind, here and there, some resistance used to take place. And mere on the postcard which is addressed to a judge of the Supreme Court or the Chief Justice of India, petitions were entertained. Now, legal education and matters pertaining to legal aid did not progress much. It was in this context and situation, the government of India has enacted what we call as the Legal Services Act of 1987. Now, under the Legal Services Act of 1987, everyone who is essentially below the poverty line is entitled to legal justice, justice before the court of law. Now, thereafterwards, it appointed a legal service authority. And when it appointed a legal service authority, it provided with the certain powers. The powers which were given to the legal service authority naturally are to frame rules, to frame regulations for purpose of smooth implementation of the Legal Services Act of 1987. Now, under the present day law, what exactly are the issues wherein the poorest of the people, poorest of the poor, can go before the court of law and get justice is the basic question that has to be considered before going further. Now, first issue is there are people, especially during the rainy season. Remember, lots of disasters are taking place in this country. And it may be due to flood, or it may be due to famine, it may be due to pestilence. And these people essentially come from the rural background. And they don't have, remember, the required education. They cannot go before the court of law. And they cannot fight. In situations of this kind, these are the ones who are given assistance by under the Legal Services Act. Now, in addition, you have a lot of people who are supposed to be drug addicts. Due to one circumstance or the other, they have become part and parcel of it. It is the duty of the society under the directive principle state policy of India to make them good citizens of this country. And they require counseling, and they require assistance, they require aid, and they require help. So these are the people who are being taken care under the very provisions of the Act for purpose of help. Now, in addition, we have other people, we have transgenders. Transgenders, remember, recently they have been called the third genders. They also need help. They are condemned in the society, but then Supreme Court, as well as the legal authority, in a series of decisions, went to the extent of considering they are men or women with the equal rights and equal protection. That had to be done. So, in addition to this, you have several other categories. You have senior citizens. The government of India is facing a series of problems. Now, many of the people in this country, and more than about 30 crores of them, are above 60 plus. And they are at times abandoned people due to one circumstance or the other. They also require assistance and help. The government of India enacted a legislation for the protection of the senior citizens. And in the event of their abandonment, or because of some tussle in the family, fight in the family, they are to be protected. First and foremost, the people who are supposed to help them are to protect them. Now, these are the things which came up. Thereafter, for example, take it this way, the widows and women, then sex workers, all of them naturally are required help and are being given help under the Legal Services Authority Act. In addition to this, we have children. They may be destitute children. They are left or juveniles. All of them are permitted, are allowed to take the excess of the provisions of the Legal Services Authority Act. Now, when I speak of this, how this is being implemented is the question. When the question of implementation comes, you have at the national level, you have the Legal Service Authority. Now, a judge of the Supreme Court will preside over it, and he has his own team of people for purpose of chalking out programs and implementing it at the national level. Then we come to the state level, we have the State Legal Service Authority. And the State Legal Service Authority will have an executive chairman. And the executive chairman is being helped by the member secretaries. And you have the office for this purpose, and they will chalk out plans and thereafter quietly execute these things to the people who have just, I have mentioned there. Now, in addition to this, you have the District Legal Service Authority. Now, when we make a mention of the District Legal Service Authority, at the district, they headed by the district judge under the supervision of the High Court, the executive chairman. Naturally, lots of programs have been done, and these programs reach the taluka level. When it reaches the taluka level, the concerned persons who are in the taluka administration, maybe the tahsildar, or maybe the BD block development officer, maybe the revenue officer, revenue inspector, or maybe the SCOs. All of them are involved in providing justice to the needy and justice to the poor people. The very object of this is to see that the entire society should be a litigation-free society, and people unto themselves are not supposed to fight. In the event of fighting, the matter has to be redressed, and ultimately it has to be settled once and once for all. So right from the taluka level, when I speak about the taluka level, remember, it may extend or it may involve people who are at the panchayat level. And with the permission, the state legal service authority and the district legal authority, members are being constituted. So in each panchayat, if there is a particular person who is distressed, who is not able to fight, and such people are taken care and they are taken before the court of law, and they are looked after. Now the other part is what type of assistance is being given by the legal service authority, maybe at the state level, maybe at the district level, or maybe at the block level, that is at the taluka level. Now, first and foremost, when we speak about the services that are being provided is legal assistance. Now, when we speak about the legal assistance, they will help you in filing the case. They will help you in paying the court fee. They will pay the first process fee as well. They will pay the translation fee, and thereafter the matter is submitted. And then in addition to this, the legal service authority itself will have a team of lawyers, and they are paid out of the funds of the court. And there are as many as in Karnataka itself, we have as many as 2,000 lawyers picked up. And these lawyers appear before the court of law. Having appeared before the court of law, they will take care till the matter is disposed. Now, for example, the matter goes for an appeal. And when the matter goes for appeal, even in the at the district level, there are advocates, and the same payment of the fee, payment for translation, payment for the processing fee, and everything will be taken care. So this is only to see justice is being rendered. We have lots of people in the villages who are SCs and SCs, who are the poorest of the poor people, who are not in a position to go to the court of law and fight their case. In situations of this kind, naturally, the case will be taken up by the legal service authority right from the village level. That means it is in the taluk initiation that comes through the taluka level, district level, then the high court level. This is how legal service is being provided. Now, when I speak of legal service is only to go to the court and get access to the court and to fight the case and to get justice. But then legal education is also most important. Now, legal education here naturally undertaken by the Legal Services Authority. Now, the Legal Service Authority conducts several programs, and these programs may be the latest will be answering the phone calls. The aggrieved party who has some problem can straight away talk on a particular day to the members of the Legal Service Authority, and they can explain their problems, and he will be giving the answers. And when he gives the answer, he will be telling them where to go, how to take up the issue, who is going to pay the fee, and who are the concerned advocates, who is going to protect them, and if any other problems are there, that can be done. Now, in addition to this, they can prepare posters, and having done posters, the matter is being conveyed. Then in institutions, they will give talks. They will go to the villages and give talks to make use of the legal services which are being provided by the government itself. Now, in addition to the posters, there will be campaigns. They go to the villages, and a series of campaigns are being conducted. And when they conduct the campaigns, they involve almost all the administrating authorities. Having involved all the administrating authorities on a particular day, the matter will be redressed. Now, this is how it is being done. Now, in addition to this, In addition to the help that is being rendered by the court, there are legal services which are to be provided by every college. Now, when I speak about the colleges, it was in 2013, the Bar Council of India enacted certain rules, adopted certain rules, and these rules were amended in 2016. And later in the year 2018, again, the rules were amended. Now, what does the amended rules say? The amended rules simply point out that each college is supposed to have a legal aid clinic. And a legal aid clinic is always assisted, supported, and looked after by a teacher who is the coordinator. Then the teacher is always assisted by a student. And this teacher and student run program in the name of the legal aid clinic should carry out various activities. Now, when I speak about the various activities, it is regarding legal aid programs. And when I speak of the legal aid programs under the latest rules, each college within the state of India is supposed to adopt 5 villages. Having adopted 5 villages, they are supposed to go to the remote villages, the adopted village. Having gone there, first and foremost, they will have to conduct surveys through a questionnaire. Now, you may be interested to know what type of questionnaire it will be. Now, the questionnaire in the village relates to whether the concerned in the village, the remotest village, whether they have the Aadhaar cards, whether everyone has taken the Aadhaar card. Thereafter, whether the concerned person who are required to have PAN card, do they have the PAN card or not? And then health card. The health card is being issued by the government, whether they have the health card or not. And if they don't have the health card, it is the duty of the people to find out and get access to the people and see them that they get the health card. Then the Ayushman Yojana, then whether they have the Khata certificate. See, you have property, but then if you don't have the Khata certificate, you are in danger. So in situations like this, it is the duty of the legal aid clinic of the college when they go to the villages to make a survey whether how many of the villagers have the Khata certificate and how many of them have any pending dispute. Suppose they have gone to the court of law, but the dispute is pending. And when the dispute is pending, they are supposed to refer the matter. The matter can be referred to the Lok Adalats, which I shall explain to you a little later. Then how many villages have SC, ST people and whether they have the certificate to this effect, stating that they are SC and ST. When once you have the SC, ST, scheduled caste and scheduled tribe certificate, they will be in a position to make use of this and get the benefit which are provided by the government of India. Then do they have annual income certificate? And from where it is being taken? So generally, annual income certificate is taken from the office of the Tahsildar. And how many of them have taken? Because it is very much required. For example, take it this way, a particular person in a village has 2 children. The children, when they go to the college from after completing the 10th standard, need an income test certificate. And if they don't take the income certificate, naturally, they will be at peril. They can't go to, just they will have to go back and take it, and it may time consuming. So in situations like this, the villagers first and foremost are supposed to know whether they have these cards. Now, this is what we call as legal education. And how many laws would you have in this country? For example, in one of the articles, it is indicated legal assistance program not only gives serving of this, but then helping them in educating the provisions of Section 6 of the Hindu Marriage Act. Now, you might be knowing under Section 6 of the Hindu Marriage Act today, where both women and men are entitled to have equal property. Daughters are also entitled to have an equal share. The people in the remotest villages are totally illiterate. They are totally ignorant. And in a few cases, they are being, remember, brainwashed, saying that they don't have property. In such situations, it is the duty Now the students who go to the villages for purpose of educating them have to know and tell them, now daughters will have equal share, whether they know the provisions of this. Then how many of them have taken what we call as the insurance coverage? So if they have insurance coverage in the event of, suppose for example, some motor vehicles act in the motor insurance. In the event of death or disability, they are entitled to obtain the insurance coverage. Then old age pension. Most of us may not be knowing that the even widow pension scheme you have instituted by the government. And the widows may not be knowing because she is forbidden from moving outside her house. And she is not given this knowledge that she is entitled to have a monthly pension. These are to be verified first after going to the village. And when the team goes there, naturally, they will be having a questionnaire. And through this questionnaire, they will get and ascertain the truth. And once they come to know the truth, how many of them require which certificate and how this can be helped, through whose agency, through government machinery, they are entitled to get it, will be explained to them. Then you have the unique disability certificate. If a person is disabled, he is entitled to get the benefit, he is entitled to have reservation in educational institutions, he is entitled to get financial assistance as well. Now, these are first and foremost to be verified. Now, when they students adopt 5 villages, naturally, in a year, they will have 2 or 3 programs. And in these programs, remember, if the program for 8 days, the last 2 days, now, after getting the questionnaire in the villages, and after realizing that how many of them need assistance, they will call the agencies. And in the 2-day agencies, there will be direct meeting of the concerned person who is aggrieved, along with the students and the officers. For example, if it is a panchayat level, they will invite everyone. Aadhaar certificate, what should be done? Then how it is being applied. Then disability certificate, how it should be done. Caste certificate, immediately they will call the Sahildar. So in presence of these officers, within no time, the matter will be resolved. And this is the very novel concept. And remember, it should be litigation free. And if there is a litigation in the village, the matter will be referred to Lok Adalats, as I just mentioned to you. And in the Lok Adalats, there will be pre-litigation process, post-litigation process. Now, during the course of litigation, the concerned court can say that the matter should go for Lok Adalat, for amicable settlement, or it may go for mediation. And once it is referred to mediation or for Lok Adalat, naturally, the matter will be settled through this means. There is no delay in waiting for the court. You know, if you go to the judicial grid of the government, you get to know how many cases are pending before the court of law. In Karnataka itself, you have more than 12 lakh cases. In West Bengal, it is maybe about 13 lakh cases. In the state of Maharashtra, it is about 20 lakh cases. And more than half of it are criminal cases. Now, when it is going to be over? Each judge at the high court or the lower court is always busy in resolving issues. That is where the concept of Lok Adalat came in. And today, a decree, a judgment which is issued by the Lok Adalat is as good as a decree issued by the civil court. This is being done through an amendment which is being made to the civil procedure code itself. So these are the advantages that are being spoken when we speak about the litigation. Now, you may be interested to know what exactly are the loopholes under the present act and how it should be rectified, how it can be remedied. Now, when we make a reference to the loopholes, now first and foremost, there is no legal awareness. Now, although there is awareness, that awareness is not expected, it is not to the extent of the expected level. Now, in the recent study which is being conducted, it is being shown that only 1% of the population of this country are making use of what we call as the redressal mechanism, which is being provided under the Legal Services Act of 1987. No, this is, remember, too meager. And in order to increase this, there should be more activities, and more activities can take place through the colleges, through the legal service authorities, going to the spot and trying to resolve the problems which are being faced in any of the cases, any of the issues that are being faced by the poorest of the poor people of this country. Then the other thing is the concerned person who is who had the aggrieved party, he should be allowed to choose the advocate. Now it is not possible for him to choose the advocate. Now this is most important. Now the third most important thing that is being spoken is when we go to the village level, there will be a kind of politics and there will be groupism. Then there will be fight between the groups, and the legal service authority, whether through the what we call as the machinery in the block level, block development level, naturally we'll have to have a series of steps which have to take to see that these won't surface during the course of the dispute. Naturally, deserving people should get justice. The very objective of the Lok Adalat is to see that everyone in this country gets justice and lives happily, and what we call as the greatest happiness of the greatest number is fulfilled at the behest of everyone. Now, there are other things also which I just intend to speak to now. When we take the state of Karnataka itself, in the year 2021, between November and December, they have provided legal services in almost 39,337 villages. This is a record mark. And the legal services in Karnataka is working very effectively. And they are going to almost every college, delivering lectures, involving the students, make them to participate in the community programs, make them help the needy in the villages, panchayat presidents, local panchayat members, women officials at the taluka level, all of them are brought together, and the officials of various agencies which give these documents are also involved in helping. And there is a great merit, and it's a compliment and a feather on the cap of the legal service authority, the state of Karnataka. I just intend to speak to you one more. In the last year, 2021 itself, the Karnataka State Legal Service Authority has dispersed 9 crores and 15 lakhs of compensation for the needy. This is, if you take for a country like India, this is a great amount, because only the distressed people who have an issue go before such authorities and plead for it. And even the Karnataka State Legal Service Authority have 2,000 lawyers exclusively for this purpose. And the future of this country should be bright, and legal service authority should be very effective. And with this, I thank the organizers for permitting me to speak on the legal services in India.